Let's read all of Why We Can't Wait, particularly the last couple of chapters where he's very specific about the need for race-based remedies to race-based discrimination.
Right.
But I have the opposite recommendation. Let's not put I Have a Dream on ice. Let's not lock that up. Let's do the reverse. Let's actually read it, all of it, because the first third of it, he doesn't use the word, but the first third of that speech is about reparations.
Oh,
he comes in there saying, we are here to cash a check.
Oh, wow.
That has been stamped insufficient funds.
Interesting.
A check that is owed to us. He uses that analogy of cashing a check about 6 times in the first page or so.
Wow.
Of that speech. To me, that reads entirely as reparations.
Wow.
Then the next the next segment of the speech is about the urgency of change, kind of getting back to the title of that book that had just come out, The Fierce Urgency of Now, following up on this book title of Why We Can't Wait. So it's speaking to liberals that are saying, oh, just give it time, it'll work itself out. And so he's saying, no, it's not. And if it doesn't, the stuff is going to hit the fan.
In this powerful conversation with Dr. Christina Rivers from DePaul University, we dive deep into African American politics, voting rights, redistricting, and the fight for fair representation. From the Voting Rights Act and landmark Supreme Court cases to the impact of mass incarceration and civic education for returning citizens, Dr. Rivers shares critical insights on democracy, equity, and justice. If you care about voting rights, racial justice, and the future of American democracy, this interview is a must-watch.
So lovely to have you on the show, Dr. Rivers. And it was lovely to speak with you last time about your work. And, your work is very, very intriguing to me on a lot of levels. Your teaching and scholarship are in the areas of African American politics, political thought, as well as voting rights, redistricting, and representation. That is a gargantuan amount of insight and research I'm sure you've done. And that seems pretty relevant right about now, especially given what's happening with Texas, the Texas legislatures and the gerrymandering. Could you speak a little bit about your work just in general and also with respect to what's happening right now? And then we'll kind of weave throughout this conversation.
Well, first, I'm going to apologize in advance because I'm getting over a cold with a really vexing cough.
Okay.
And so hopefully I won't interrupt too much with that.
Sure.
Second, thank you for having me on. And
absolutely,
I'm looking forward to our conversation. So to answer your question, when I was in grad school in the 90s, the redistricting issue was really huge for those who were studying voting rights. And I got pulled into that topic through the recommendation of a fellow graduate student to take this class on voting and redistricting. And it was one of those classes where the proverbial light bulbs were just exploding through the whole term. This is 1993, and the Supreme Court had just, I got into the class around 1996 maybe, but the Supreme Court had recently handed down a decision that was quite a restrictive decision with respect to the use of race in redistricting in states that were covered by the Voting Rights Act, by what they call the preclearance provision of the Voting Rights Act. And these were states that had a history of voter suppression based on race.
Is that Section 5 where
this would have been Section
they needed
5,
to get federal approval if they change anything with the voting? Yes.
So North Carolina had redistricted in 1990 and submitted that plan to the Department of Justice. The Department of Justice, which was then headed by Janet Reno, sent it back and said you can create a second black minority or majority black district. And so the state redrew the districts, and the DOJ approved, and so they redrew the map with 2 barely majority black districts, like 50.1% majority black. And the DOJ approved it. It was subsequently challenged, and the court upheld the challenge, arguing that the districting violated the Equal Protection Clause, with a rationale that a lot of us felt was deeply ahistorical in terms of not looking at the framers' intent for either the 14th Amendment or the Voting Rights Act. And so the responses to that case filled rooms full of law review articles.
What was the rationale, though?
The rationale was that there was no equal protection, that whites in that district were denied equal protection.
Isn't that amazing? Because, there's also a history of the 14th Amendment being co-opted by corporations to establish personhood.
Yes.
So it's really interesting how something that's very intentional to help a very specific part of the population, that being African American people, gets co-opted, twisted, and then used in a way that's completely antithetical to its main purpose. Well, which doesn't surprise me at all.
Judge Leon Higginbotham wrote an article at the time that, to quote him, I think verbatim, said that this decision turned the 14th Amendment on its head. And so the decision also didn't take into account a lot of the historical factors behind this redistricting, one of which was that the second map that drew these two majority Black districts, those two districts elected the first Blacks to Congress in 1993, it was. The first Blacks elected to Congress since 1901. So they accomplished the goal. The other thing that the court got backwards in a very cart before the horse part of its rationale was that Justice O'Connor referred to this redistricting as political apartheid. What led to the case was that the districts were ugly. They looked like your kind of classic, crazy, ink splot, gerrymandered type district, which most districts look like, even then. And they claimed that it violated some certain standards that were laid out in an earlier case, sort of the 3 C's, one of which is that these districts be compact. What's been happening over time in redistricting, and I don't do redistricting, I don't draw those maps, that's a whole different science. But the degree of precision with which legislators can draw districts lines around primarily partisan interests. How do we draw them around the Republicans or the Democrats has gotten so surgical that this notion of a nice, neat square or circle or oval shaped district has gone by the wayside. Many districts look the way they do because they're following, for example, natural topographical features like rivers or mountains. And North Carolina is very hilly with a whole lot of water and rivers, and you've got that whole outer bank. And so a lot of district lines are dictated by the topography that's out there, or even train lines. The other thing that she didn't take into account, because she said this type of redistricting, now I'm missing the words, it was something like tantamount to segregation. And again, cart before the horse, because the segregation had long pre-existed the district lines. One could mildly argue that it's reinforcing it, but it certainly didn't create it. And so there was all this sort of backwards logic going on. And so they didn't determine that the districting itself was unconstitutional. And I misspoke, and a lot of people have misspoken on this, but they did determine that the plaintiffs had a 14th Amendment interest here. And so they directed the state to redraw the districts. They did. The districts were redrawn in a way that was a little less uneven. After which the elections happened, the election stood, and these 2 Black representatives, I think, have African Americans have represented those districts, I think, ever since then. And it is true that one of the districts was extremely weird looking, in part because, based on the reason I just gave, they had drawn the district right down the I-95? And highways tend to have thicker populations, just by dint, again, of where it's more convenient to reside, where you have commerce and things like that. Highways attract people, at least those highways that aren't used to divide entire neighborhoods.
Exactly.
And so that was another one of those sort of man-made topographical features that's really common in a lot of districts, is that you have a lot of population concentrations around major highways. And so there was so much made about the look of the district by the opponents of these districts, and Justice O'Connor really bought into that argument, again, without looking at the context. Now, of course, I'm speaking of this case in a very critical way because that's how I learned about it. But it's historically, there was just so much that was left out of this case.
Yes.
And so that's how I got into it. And so the big issue is, to what extent can you draw issues that are safe districts for African Americans or historically marginalized voters without violating that? It makes it more difficult to do that without violating the Equal Protection Clause. There were so many things that were wrong with this decision. We could talk about this all day. But so, for example, the two majority Black districts were each about, one was 51% Black, I think. The other one was something like 50.4% Black.
Okay.
The standard threshold that was used at that time to determine what would be considered a safe majority Black district was 55%. So this is well under that threshold, which tells you there was crossover voting by whites for these Black candidates. That was missed in the complaints about this district. That particular success, I would say, was missed in this complaint about these districts. The other, this thought just went out of my head. There was no mention made of how many other districts in the state looked crazy. So, for example, one of the challenged districts looked kind of like a hand, and it was interspersed like two fingers, two districts. One of those districts was one of the districts that was being challenged. The other one was a predominantly white district. Nobody made an issue about how the irregularly shaped predominantly white districts, some of which were 90% white. There's no issue made of that in anywhere that I've read, either in the opinion or in several of the Friends of the Court briefs, not even the Friend of the Court brief by the Congressional Black Caucus. And they didn't submit in that one. Sorry, they submitted Friends of the Court briefs and subsequent similar litigation building on this particular case. So this decision got the Congressional Black Caucus really active in this issue, because they had been so active in reauthorizing the Voting Rights Act in 1982.
And when did the Congressional Black Caucus form? Do you have?
I've seen two dates, roughly 68. Some people say it was 1970, but it started with about a dozen people, either in 68 or 70. And at that point, I think it had about 26 members, and it was very active in reauthorizing the the Voting Rights Act in 1982.
When you say reauthorizing, what do you mean by that?
So the Voting Rights Act, when it was originally passed, it had a 5-year, I don't want to say sunset, but legislation is often reauthorized, extended, revisited.
Oh, gotcha.
So in 65, it was passed in 65, reauthorized in 70, again in 75. Those were smaller expansions of it. In 82, there were really, really big expansions that were made, in part involving expanding Section 5, but also creating this other section that provided a pathway to litigate after the fact if there's harm from a district. But the 1982 reauthorizations were very, very contentious around Section 5.
I bet.
And it was Barbara Jordan from Texas was very involved in expanding the Voting Rights Act. She's the one who actually really ushered through adding language protections, Section 203. But others...
which helps who?
People whose language, who are not native English speakers. So this is what leads to things like the printing of bilingual ballots.
Oh, I see.
Or having bilingual staff,
Interesting.
Yeah. So this was, and representing Texas, she had a significant portion of her district who were non-native English speakers.
Oh,
so there was a lot of really interesting outcomes from the 1982 reauthorizations. It was then, in that time, they reauthorized it for 25 years, not the usual 5 years. And then in 2007, they reauthorized it again for another 25 years.
Well, now this brings me. I wanted to ask you, if I may, about the case. It's the Northwest Austin Municipal Utility District
I
number
gotta go
1.
back and restudy. I haven't read that one in a while.
Well, it was decided in 2009, and then the Supreme Court dealt with Section 5, and I think kind of gutted it.
In 2000, in the Namudno district, this is one of Roberts' first decisions that he authored. The majority made it very clear. They upheld
Chief Justice Roberts.
Chief Justice Roberts, The court made it very clear that Congress, and I'm speaking very casually here, if Congress doesn't do something with Section 5 or get rid of it, we will. That was really the gist of it. That was really the gist of it.
That specifically requires, if states change the way people vote, they have to have that change approved by federal officials.
Any election law change, if you're in a covered part, it's referred to the coverage formula. If you're in a part of the country that has been determined to have a history of racial or ethnic suppression of classes of people, so this largely covers a lot of the former Confederate South, but not only that. Then any election change that you make, whether it's redistricting, whether it's election hours of how late your polls are open, where you move your polling stations, anything like that has to be cleared by either the Department of Justice or through the DC courts. I'm a little rusty there, but it has to be cleared by a federal entity, and it's almost always been sent through the DOJ. And so the NAMUDNO, which stands for something like the North Austin Metropolitan District, I think it was a water district, so it was a
utility district.
District, yes. One of those small cases, if you will, that had broad outcomes.
Right.
That's where the court kind of did the shot over the bow to Congress to fix the VRA in a way that would restrict Section 5, ideally get rid of it. Some of the big debates in
the VRA is the Voting Rights Act.
I gotcha. So one of the big debates in 1982 over Section 5 was that it had become obsolete. The civil rights, the Jim Crow era was over. So Section 5 was obsolete, and it's no longer needed.
Can I just say something about this? That it seems like this was the same rationale that happened with the financial, but leading up to the financial crisis of 2007 and 8, where the rationale was, we don't need these protections that we put in place from the Great Depression. It'll be fine, even though those are what kept our economy somewhat stable and secure for people. And the moment you pull these protections away, oh, geez, all of a sudden there's all types of mischief and mayhem. And so, it's just kind of par for the course, Dr. Rivers, that oftentimes the safeguards that we put in place are, taken away. And, with, as I was saying, with the bank deregulation that happened leading up to the housing crisis and the worldwide financial crisis in 2007 and 8. Well, and here it seems to be the similar paradigm.
It was similar to when the court stopped enforcing the 14th Amendment after the Hayes Compromise. There was a similar rationale there that, the Civil War is over, the country is reunited, people aren't enslaved anymore, and so there's no longer need for some of these laws to exist. This was their rationale when they overruled the Civil Rights Act. In the Civil Rights Act cases of 1875, it's a really similar rationale. And of course, nothing could be further from the truth, right? So in the 80s, in the 82 reauthorizations, there was this framing of the Section 5 as keeping states in the penalty box. And they really, that phrase came up a lot. If I read all the congressional record on these hearings, and that phrase came up a lot. And this was northern
What does that mean?
We're punishing them too long. So Section 5 is a penalty box, and you're keeping covered states in a penalty box, and that's not right. Penalty boxes are supposed to be for a few minutes, not for years and years and years. It was a somewhat disingenuous claim because the whole the Voting Rights Act also has a section that's called bailout, which says if a state has behaved well for 10 years, hasn't engaged in any of these egregious acts of discrimination, then they will be bailed out of coverage and they will no longer have to ask for the Department of Justice permissions to get whatever changes they make. So in other words, if it is kind of like a penalty box, right? Act right, calm down. It's like putting your kid in the corner. Redeem yourself, pun intended. And we'll take you out of the penalty box, but there was always a possibility to be put back in, right? That's exactly how it's supposed to operate.
The language gymnastics that we see attorneys put forth to shape perspective in this particular way, there's no penalty. I mean, from my limited perspective, there's no penalty box. It's just a check and balance that's put into place by getting federal approval because states are going to run amok and do whatever they want and generally push forth racist agendas.
Well, and that was the rationale of the Democrats who pushed to maintain it and to expand it. And so that's what happened in 1982. Not only was Section 5 upheld, they expanded the coverage to certain other areas of a few other states.
Section 5, you mean?
Yes. The coverage, there were some states in the North, for example, or in the Northeast, where there was evidence of voter discrimination against people of Asian descent or Native American descent in the Plain states. So some of those coverage pieces were extended to some of those areas. Again, there had to be proof of the discrimination, and then these regions were put under Section 5's auspices. So that is exactly how it was designed to work. And of course, you just had two camps on, how that should work. So one of the arguments, there were two solutions that were put forth, proposals, I should say. Either get rid of it altogether. This is opponents of Section 5, or make it absolutely national, federal for everybody to do this. And in a perfect world, that would be great. But the people who proposed that knew that the DOJ didn't have the staff. The Civil Rights Division was not big enough to monitor election changes from every single, electoral district or board of elections or anything like that. So they knew that was sort of a false promise. And so that argument did not win the day in 82. You fast forward to that Namudno case, and the court launches the shot over the bow of Congress. And, here's where you get into these interesting discussions.
And this is in 2009, right?
Yeah.
Okay.
And here's where you get into these interesting discussions about framers' intent and originalism and all that other stuff. And where the court and the Congress go back and forth and check the court and Congress. So here you have on the one hand, the court saying Congress needs to fix itself, this law. And then you have the Congress coming back and saying, well, the court just got it wrong. And so in the 1982 revisions for reauthorizations of the Voting Rights Act, those were also motivated by a much less widely discussed decision that I think was decided in 81, Mobile versus Bolden, that also had a very restrictive approach to the Voting Rights Act. And so when Congress convened, the committees convened around reauthorizing the Voting Rights Act in 82, they said, okay, we have to fix this decision that the court made because they're taking the Voting Rights Act in a different direction. This is a very common thing that happens when the court messes with congressional laws, and you don't hear about this much. But the Congress was really explicit. We have to shore this up. This is the decision that the court made. So we have to shore the Voting Rights Act up away from that type of decision, to shield it from that type of decision. They were very explicit about it. You fast forward to 2009, you get that shot over the bow. Prior to this, and sorry, this is a little backwards.
No, go ahead.
The Congress had already reauthorized and strengthened Section 5 in 2007.
Mm.
At that point, they were saying, we're fixing the Shaw decisions and some of the decisions that came after that. And again, they were very explicit in saying the court interpreted our intent incorrectly. And then you get this shot over the bow and made it very clear, to me, Justice Roberts made it very clear that the first chance the court got, as soon as they could, they would invalidate Section 5. And that's right because my book came out around 2011. So I had a chance to and I don't normally predict, but we saw that writing on the wall.
And when did they invalidate Section
2013.
5? Oh, 2 years later. I was going to ask you. So your book is The Congressional Black Caucus, Minority Voting Rights, and the U.S. Supreme Court. Is that
long
correct?
Title, not my title. I screamed that from the rooftops. It was not what the publisher did with the title. That was the subtitle. Yeah. Yeah, the title was supposed to be Caught in the Crossfire, and with the analogy that minority voting rights and power are being caught in this crossfire, ideological crossfire, interpretative, if that's a word, crossfire, between the Supreme Court and the Congressional Black Caucus.
Okay, and so you basically explore the historical and legal struggles surrounding minority voting rights in the United States, and you focus on the role, what's interesting is I read, just very briefly, if I may read, and I think this was published by the University of Michigan Press. Mm-hmm. Now, what's interesting is I just read the description of the book actually this morning. Again, I knew about it, but it says, the Congressional Black Caucus and the Supreme Court disagree about the intent of the Voting Rights Act and the 14th Amendment, which we were talking about just a second ago. And what's interesting is it says you examine a series of high-profile districting cases, such as the one we just referred to, and you evaluate the competing approaches to racial equality, and concludes, and then it says, surprisingly, that an originalist, race-conscious interpretation of the 14th Amendment, along with revised states' rights position regarding electoral redistricting, may better serve minority political interests. Why in the heck would they say surprisingly? That doesn't surprise me that would be your view, that actually a race-conscious interpretation of this is the correct one, because that is specifically was the intent.
Because there's always surprise that there was a race-conscious framing of the 14th Amendment. That's where people get surprised.
Why?
And because they don't know it. And so when I was reading through, anytime I read, even Brown versus Board of Education, I've argued that this comes from kind of this colorblind reading of the of the 14th Amendment I argue that it came out of Justice Harlan's dissent in Plessy versus Ferguson. Where he had that, famous one-line statement, our Constitution is colorblind. And that alone is somewhat true, but it's also out of context. Now
I just have to say one thing.
We vaunt that dissent, right? Because he was bucking the decision, right? He was a one-man holdout. And so we vaunt that particular dissent because that was a very daring thing for him to say in 1897. But it's also an incomplete statement. And it's also an incomplete coverage of his dissent, which also conceded that whites are the dominant race. He says, but in the eyes of the law, our Constitution is colorblind. So he too is kind of parsing theory versus reality.
Totally.
The Brown versus Board of Education court picks up that our Constitution is colorblind because now you've had decades of very race-conscious discrimination in colorblind language. And so there's been this bait and switch now going on for 60, 70 years. And so they latched onto that. Our Constitution is colorblind. Again, kind of ahistorically without recognizing that the original framing of the 14th Amendment, if you look at those congressional debates, they're entirely steeped in race. And you had some legislators who were, really racially egalitarians. You had others who were just sort of more utilitarian about it. And then, of course, you had the racists, right? But you can't take race out of the framing of the Reconstruction Amendments. But something about the Plessy dissent, the Brown opinion, created this notion, which is what I grew up when I was in school myself, in high school, of this colorblind world. And this is the goal. Colorblindness is the absolute goal without ever really thinking about what that meant.
Yes.
And, even if you read through Martin Luther King, they take him out of context. He has certainly valued certain notions of colorblindness, but he also was very much about race-conscious solutions to racial discrimination, particularly around voting rights. He argued that blacks, like everybody else, should vote as in a racial bloc in the same way that the Irish do, that laborers, interests do, that whether it's a professional interest or racial interest or any other kind of common interest, community interest. And he uses that literally, he talks about black bloc voting. He does this in two of his books, but these are books that often clearly haven't been thoroughly read. And so by the people who are invoking him, you don't hear that going on as much now. Because I think more has been written about that hypocrisy. But the Shaw versus Reno court in 2013 was steeped in that sort of one-dimensional ahistorical concept of colorblindness without looking more deeply into the actual framing of the 14th Amendment, which would certainly allow for race-conscious remedies to race-based discrimination. And they didn't examine, and I always thank my dissertation advisor for bringing a couple of cases to our attention when he taught. The slaughterhouse cases in Strader v. West Virginia, and those were some of the first two opinions in which the court had to interpret the 14th Amendment. And they interpreted them in extremely race-conscious ways. In fact, in the Strader case, and there's a whole section in the book about this, the court essentially, again, I'm sort of simplifying the words, said, we can't imagine another group invoking the 14th Amendment than formerly enslaved people.
Right. And the 14th Amendment, just to be clear, simply, basically at its heart is equal protection under the law.
It's equal protection, due process.
Due process.
Now due process was in the Fifth Amendment, but the 14th Amendment, because it says no state shall deny, et cetera, et cetera, et cetera, to pull due process into that now nationalizes it.
I see.
This is before the Fifth Amendment later became nationalized. And so the court made these super, super narrow, very race conscious interpretations in now you got me. I want to say 73 and 75.
Okay.
Shortly thereafter is when the court expanded the 14th Amendment to cover corporations in the Santa Clara case.
Is that around, you're talking about in the 1800s, around 1881 or so?
86. I think it was 1886.
1886. Oh, okay.
So I think it was 1886.
So just for our audience, just to be clear. So we have the 14th Amendment with its intent, as we were just talking about, to really protect the rights of recently enslaved, now newly freed people in the United States. And then all of a sudden, corporate America.
African descended people, period. Because it was also, from my understanding, framed in a way to overturn, congressionally check the court's decision in the Dred Scott case, which didn't just decide that Dred Scott or enslaved people had no rights to respect. It said people of African descent had no rights that whites needed to respect, whether they had ever been in bondage or not. So even if you were born in Pennsylvania, had never been enslaved, people of African descent, he basically said they have no rights that whites need to respect. And so the 14th Amendment, the way I understand the creation of it, was done in part to overturn, to check that rationale. So it wasn't
And
just
then as we,
for the rights of recently freed people, but for anybody of African descent.
I gotcha. I did not know that. And so now we fast forward a little bit, and then corporations are co-opting the 14th Amendment to establish their own personhood. So just so you know, for our audience, you know, when Citizens United came down not too long ago, that wasn't the first time that corporations were saying, hey, we should have the rights of the people. Unfortunately, the flip side of their personhood is that they don't have any real accountability. And so that seems extremely antithetical to what the 14th Amendment is really about. But, you know, that's what it is. And so it's a real shame that happened.
It's really a lot of ideological gymnastics, I guess, or not ideological so much, but rhetorical
language yes,
rhetorical gymnastics, and again with no historical basis. It's like I have argued that when the current Supreme Court majority, or the Supreme Court majority as it's existed since the 80s, their interpretation of the 14th Amendment seems to be rooted in Brown versus Board. It seems to go no further back. And the irony is that, very loosely speaking, ideological conservatives tend to take what they call an originalist approach to the Constitution, which is what do the framers intend? Not what do we intend for it now, but what do the framers of a particular provision intend?
Okay.
Or what does it literally say?
Well, I mean,
that last piece is really constricting, but
that's the part. But what you just said before, though, what were the framers intending, or the people that made, like, the intention of the 14th Amendment? I bet they would find some rationale to misinterpret that, even though they're saying, well, we're trying to go by the original intent. Even though the original intent is antithetical to probably what I don't
know how they would do that if they read the congressional record on that. And so my guess is there's not much reading of the congressional record on that. Now, ironically, one of the most helpful books that I read about this interpretation was written by somebody who was considered to be an academic, more conservative than not scholar.
Okay.
And he was making this argument that, I think, to quote him, the framing of the 14th Amendment, which was shot through with racial considerations. But of course, the term conservative and liberal have changed. Those terms have changed over time as well. But
totally.
Yeah, contemporary legal conservatives tend to take an ahistorical approach to the 14th Amendment when it comes to race, in my view, that stops at the Brown versus Board decision and doesn't go to the original intent of the actual people who passed the amendment or who framed the amendment in the first place.
And what is there, if you could just characterize their interpretation with Brown versus Board of Education, their limited interpretation?
The limited interpretation is that you can only that colorblindness is the only way to implement the 14th Amendment. That the 14th Amendment does not tolerate race or identity conscious approaches to race or identity conscious discrimination, even though that kind of discrimination still exists. So it's not acknowledging that this discrimination continues to exist, but even if it does, it still says, well, you can't attack it that way. It has to be done through colorblind measures, which really tends to water everything down.
It's so interesting, this huge push to not really, to me, the way it strikes me as an outside observer is very simply that there's this tremendous push to not give context that is so unbelievably obviously necessary to understand what's going on here. And so you can rationalize basically a lot of racist policies. And this cuts across different paradigms. Context is so critical to understand what's going on. And there's this dramatic and aggressive advocacy not to do that and live in this utopian kind of box thinking, oh, well, we don't need to consider race. Well, actually, I think we probably do, because the way this country started was a lot of it economically was there were a lot of people kidnapped from Africa, brought here, and to do labor under severe, terrifying circumstances, not be paid, get abused for hundreds of years. And if you don't take that into account, what's the point of, you're not understanding anything. And we see this again and again and again. And so also in the context of the debate about reparations, a lot of people say, oh no, we're past that. Really are we? You look at the wealth gap in this country, you look at all of these statistics that are a direct result of how this country started. So go ahead. I'm sorry.
Well, no, you're preaching to the choir, clearly.
Okay.
This is why there's such resistance to critical race theory, because everything we've just talking about has, was really uncovered. It's not quite the right term, because the stuff was out there, but critical race theory, which is a scholarly movement that started in law schools, was really
around
emerged,
the 70s, right?
I want to say late 70s, early 80s, to really shed light, literally and figuratively, on all this stuff that's been hidden in terms of original intent and that type of thing. A lot of cases that have just kind of been buried by the wayside, like the Slaughterhouse cases, like Straughter, they haven't been overturned.
I see.
And so critical race theory really sought to expose these conflicts, these hypocrisies, these oversights, whichever term you want to use, not only to expose them, but then to demonstrate how how not looking at race and taking this colorblind approach has allowed the exacerbation of the very inequalities that the 14th Amendment was at least in partially intended to abolish. And so, you had really, really very thoughtful, hardworking scholars from across different identities who created some very, very good scholarship around this, a lot of good scholarship around this, for 2 full decades. That movement was still was active. But it is anathema. It is absolutely anathema to ideological conservatives when it comes to race and law. And of course, more broadly, it's also, what's behind whatever the language of the decade is, whether you're calling it diversity, multiculturalism, DEI, all that stuff, all that is, which emerged from the civil rights movement and all these other identity movements. The civil rights movement started with the African American situation, but many other movements joined in on that. And it led to, this, again, revelation of these various inequities going on across identities, intersecting with different identities, to borrow from Kimberly Crenshaw's arguments, that was really beyond race and ethnicity, but also included, gender and sexuality and sexual identity and class and all the way these different, because none of us is one identity, right?
Of course.
And looking at the overlapping aspects of that and how the inequities kind of feed and build on each other, which is
totally,
of course, something that Frederick Douglass got at in his time. And so critical race theory by its nature was historical. It was very philosophical, and it was very adamant that we take all these considerations into account when making legal arguments and legal decisions, particularly if you're a judge or a justice. And the Supreme Court majority at the time critical race theory was really emerging and at its peak completely rejected that. And so there's always been a minority on the court, I think, who, might be convinced by some of those arguments, but it's always just been a minority, and now a bare minority. Has it gone away? No, you don't hear about it much. It's now, but it's the same to resist, it's the same resistance of any open discussion of race and identity and inequality.
Yes.
And again, a rejection of any discussion of engaging in identity-based solutions to identity-based discrimination.
Yes.
And it's what's led to Martin Luther King being vaunted as this patron saint of colorblindness, and completely misunderstanding his philosophy around colorblindness. And so, and I have,
because he said we want to be treated by the content of their character, and it's
that
like
one line, I had a whole speech. And so Michael Eric Dyson, wrote a book about King, and one of his opening comments was how King has been funneled through, I think he said something like 37 words out of his whole legacy, right? That one sentence.
Right.
And so his proposal when he wrote this book on King around the early 2000s called I May Not Get There With You, was to let's just put the kibosh on the I Have a Dream speech. Let's just stop reading it and let's read his other stuff.
Right.
So now I 100% agree with reading his other stuff, particularly a book that had been out of print from what I could tell. At least I had trouble finding it for decades. Where Do We Go From Here, which thankfully is back in print. Most people have read Why We Can't Wait, or they've read Letter from Birmingham speech, or they've read the I Have a Dream speech, and that's it. Now I totally agree. Let's read Where Do We Go From Here in particular. Stride Toward Freedom, which was one of his first books written in 1955.
Yep.
Let's read all of Why We Can't Wait, particularly the last couple of chapters where he's very specific about the need for race-based remedies to race-based discrimination.
Right.
But I have the opposite recommendation. Let's not put I Have a Dream on ice. Let's not lock that up. Let's do the reverse. Let's actually read it, all of it, because the first third of it, he doesn't use the word, but the first third of that speech is about reparations.
Oh,
he comes in there saying, we are here to cash a check.
Oh, wow.
That has been stamped insufficient funds.
Interesting.
A check that is owed to us. He uses that analogy of cashing a check about 6 times in the first page or so.
Wow.
Of that speech. To me, that reads entirely as reparations.
Wow.
Then the next the next segment of the speech is about the urgency of change, kind of getting back to the title of that book that had just come out, The Fierce Urgency of Now, following up on this book title of Why We Can't Wait. So it's speaking to liberals that are saying, oh, just give it time, it'll work itself out. And so he's saying, no, it's not. And if it doesn't, the stuff is going to hit the fan. Again, I'm really simplifying this language. Almost not using threatening language, but very ominous language, right? So that's the second chunk of that speech. And then the third chunk of that speech is all these aspirations, all these dreams that he has, right? But that second chunk, there's a whole theme there, and you can count it. He says it's about 12 times. Now he's a minister in the Southern Baptist tradition. You repeat yourself, right? So he does that. But he says, we will not be satisfied until, we will not be satisfied, we will not be satisfied, over and over and over. So that's urgent, right? And then that last third of the speech is again where he gets very aspirational and he talks about these dreams. And the content of our character was one of about 8 other dreams. And so the fact that that whole speech has been boiled down to one dream, overlooking the urgency piece, overlooking the reparations piece, is why, if it were up to me, I would have the exact opposite. Let's not put that thing on ice. Let's have everybody read that whole speech. And now I go on rants about this because I teach a class, a first year seminar on King and Malcolm X. And so we go through that speech. And so that's how I can tell you, he said this 6 times. He said that 8 times. And so it does have these 3 kind of chunks to it. But that first part, if you look at the first part, he's talking about reparations.
Interesting. Well, it's so fascinating to me. And this is just another illustration of that, which is there's, as I said before, there's this real tremendous an aggressive push not to view things in context. So when critical race theory came out, particularly when the 1619 Project came out as well, and both of those have been attacked and vilified and misconstrued purposefully, because what they do is they're pointing out systemic issues with race and class, particularly with race. And that's going to puncture a huge hole in this ridiculous but yet powerful propaganda that we have in this country, that we have this colorblind society, and you just have to, pull yourself up by your bootstraps and everybody gets a fair shake. That's a bunch of baloney. And so if you don't understand that certain people have started on third base trying to get home, to use the baseball analogy, as opposed to a lot of other people that haven't even gotten to first, and they're also got a broken leg and they don't have half a bat cracked. Yeah. I mean, it's ridiculous to just put that forth. It makes absolutely no sense. But then we have tremendous amount of propaganda that's intentionally misunderstanding this. And so you thwart against that. And now, if I may pivot to some of your work, and this is how I found out about you and your work through our mutual friend who I've taught with at Northwestern's Medill School of Journalism, Michael Dees, who we were just having this conversation randomly. And then I said, "Oh, so what are you up to?" And he said, "Well, I'm really, really inspired." I actually said, "What is inspiring you?" Something to this degree. And he said, "Well, I've been teaching incarcerated people at a prison." I said, "Whoa, that's heavy." And we just had this fascinating conversation because I think I may have mentioned to you before that I saw this wonderful documentary where Bard College went into a jail and they taught people college level courses. And what happened? What didn't surprise me at all? I am very clear, having been a teacher in a variety of capacities at a variety of levels, mainly at the college level, that if you meet students where they're at in a powerful way, as opposed to having them fit in your boxes, so much is possible. And it is amazing. And so when I saw that documentary, it really resonated with me. Then Michael reignited that passion that I have. And then he said, "Well, if you really," and I said, "Well, I'd love to have you on the show and interview." He said, "Well, you might want to," and I still want to do that, "but you might want to talk to this woman I know, Dr. Christina Rivers, and et cetera." And I said, "Oh, great. So could you tell me a little bit about your work there?" I know you were in Statesville and then in another prison. And there's so much that, I mean, if you could just give me the broad strokes, but there's specific things that I want to ask you about, particularly the legislation that you wrote that requires civic education for those re-entering society after being incarcerated. I mean, it's just fascinating. But if you could just talk about that work generally and how you got into it, because it seems to be an extension of what you've already been interested in, particularly after the crime bill of 1994, where so many Black people, well, people in general, but particularly Black people, and particularly Black men, and decimated the Black family. The 1994 crime bill, also known as the Violent Crime Control and Law Enforcement Act of 1994, sponsored, I believe, by Joe Biden and written and signed into law by Bill Clinton. And that implemented the 3 strikes and you're out, which has had tremendously devastating effects on a wide swath of our population. If you could speak to that, I'd appreciate it.
Yeah. Well, first off, I will get to talking about the law that was written about civic education, but I got to say right off the bat, I didn't write it. My students did.
That's even more impressive.
They wrote it. I typed it.
And
because I was getting it handwritten.
What facility was this at?
That was at Stateville.
Stateville Correctional Center. Stateville. And where is that? Where is that located?
In Crest Hill, Illinois. Yeah, it's
Crest
closed.
Hill, Illinois?
Yeah.
Okay.
Yeah. So they closed it in last fall of October of 2024. It was, I think, being held up by layers of paint and dust and mold. It was 102 years old.
Wow. Wow. I'm laughing to keep from crying. That's horrible.
A very Shawshanky looking place with some really beautiful educational projects going on there in the midst of it all. But Yeah, the 94 crime bill, the irony, so many ironies there. I'm from California, and that state passed similar laws in the 80s. And so what the 90s legislation did, by the 90s, a lot of states were passing these laws in large response, in California in particular, to two things. The raging crime wars around crack in particular, and the sort of outsized concerns that created amongst not just lawmakers, but people who lived in communities where this was happening. It was a very, very difficult thing to deal with in those communities.
Interesting. This was in California, you said?
So California
around passed, what time did you say?
I want to say 86 maybe.
And this centered specifically, the catalyst around this was the crack epidemic.
One catalyst was the warfare that came out of the crack trade in LA and in Northern Cal, to a lesser extent San Diego, where I'm from, but it really dominated headlines.
Wow.
Rightfully so. It was a period of incredible violence. There's been a lot of studies that have come up since then to kind of talk about how that war even got started, but it was tough.
That's what's coming up for me and a lot of people. There's documented evidence about the CIA's involvement in putting
we didn't
drugs.
know that then. Yeah, folks didn't know that then.
Absolutely.
And so all people knew was that they were living in very dangerous areas that they wanted to have fixed. And so it's similar to the Rockefeller laws of the 70s, where that was really kind of the precursor of the three strikes idea. That had a lot of support from Black community members and leaders in Harlem and in Brooklyn and some of the areas where the drug issues were the most rampant as well. There's a really good book written about this.
What was the Rockefeller law that you were referring to? So
the Rockefeller laws were passed in the early 70s that took a very punitive approach, particularly to drug use. And this is during the later heroin epidemic.
Oh, wow.
Sort of a legacy of this sort of 60s explosion of heroin use, but that really kind of landed and had long been in communities of color where law enforcement sort of tended to allow that to happen more than in other communities. So people would come to those communities, again, intersecting with returning soldiers. Sort of the end of the 60s, all that stuff kind of peaking in certain areas of New York. And there's a book written about this and the title is escaping me. It's probably on my bookshelf back there, by Michael Javen Fortner.
Okay.
That really looks at African American leaders' role in pushing for the Rockefeller laws.
Interesting, because they probably just, like as you said before, they didn't really know how this started.
Yeah, you want the safety.
And that's totally rational on its surface.
Not recognizing what the ramifications of these laws is going to be.
Right.
Of course, in New York, this is right after Attica, and so everybody was still freaked out about Attica because, again, the prison uprising.
Okay.
So there was a prison uprising in New York State, Attica Prison in New York State in 1971, I think it was.
Okay.
That was also very grossly misreported, where many corrections officers were killed by, I think, state police, but the reporting was that they were killed by incarcerated people, not by what would be called friendly fire.
Right.
So there's a recent book about that has been written that really digs into the coverage of that and what really happened, called Blood in the Water.
Okay.
By Heather Thompson. But Michael Javen Fortner wrote this other book, again, whose title is escaping me right now, that looks at the role of Black leaders, particularly religious leaders, in areas of New York that were really hit hard by heroin epidemics, and that endorsed, let's take a more punitive approach. If we've tried to take the humane approach, it's not working. Let's take the more punitive approach. So those Rockefeller laws are some of the ones that I think that first embedded this notion of three strikes. And you're
interesting.
out. And then I think after about 10 years later, I think actually it was, I have to go back and reread this. I think it was Washington State that in the 80s passed a three strikes law, and then California. The other impetus to California passing the law, from the research that I did on it, was a very tragic case of somebody who did their time, got out after duly serving their sentence, committed a horrible crime, and killed a child.
Oh.
And the state, the reaction was, how did this guy get out? And the fact was he got out because he served his time. He didn't get out early. And he had been a repeat offender. And so that also was a catalyst to say, we cannot, if this was his third strike, if something like that, if you do 3, you got to stay in for life. And so California was one of the first big state since New York to pass these really very express, very comprehensive 3 strikes laws, which immediately started to fill the prisons because it led to more arrests. There were already increases in arrests anyway. Well, now if you're going in for life, you're not getting out. The prison population just explodes exponentially.
Yeah.
And so the crime bill of 94 was really following up on other states that were starting to institute these laws, where these laws, of course, end up being very expensive because it's not cheap to incarcerate people.
Exactly. Totally.
And
then there's this whole prison industrial complex that keeps on expanding.
Led to the creation of private prisons. Now, private prisons are still a small proportion of those who are in prison. They're now being shifted more towards immigration and detention, but it did lead to that. And it led to
a huge incentive to keep those jail cells filled, which led to a lot of corruption.
It's a profit. It's a profit thing. But let's be clear, what I'm learning, and I've learned so much from working and teaching in this prison, and then I'll get to how I got into that.
Please.
Even state prisons, whether it's state or federal, they may be run by the state and largely funded by tax dollars, but their contracts are through so many other private entities, whether it's providing food or medical care, or all sorts of other services, that you really can't fully call them fully public entities, because they're so connected up to the private sector to provide certain aspects of their services, healthcare being one of the most entrenched private partnerships that tends to be most expensive and often the least productive. But that's for another subject. So the way I got into this is I didn't...
Most expensive, least productive.
Least productive, right.
That's pretty much the thing,
And so, like many things in my life, this phase found me. I had always ironically thought I would teach in a prison when I retired. And I was thinking maybe I'll teach in a women's institution. My mother was an adult basic ed teacher. And later on in her career, she noted that she was getting students who had been incarcerated and were getting out and wanted to finish up their GED. I think at this point, this might have been before GED courses were required while you're in prison. And so that was becoming a larger proportion of the people that who were in her classes. And there was one moment where she taught in a sort of a youth camp, for lack of a better term. This is like back in the early 70s, late 60s. Loved it. She really loved it. It was just for the summer. And she was looking forward to doing that every summer, where it was up in the mountains. It was in Clear Creek, Nevada, so they put these teachers up in a trailer outside of this detention center that was up in the mountains. And I think the presumption was get these kids out of the city, just fresh air, totally different environment. Powerful. And it was. And one of the few times I ever saw my mother cry tears of frustration was when that program was ended, because she recognized how valuable it was. And personally speaking, she loved being up in Clear Creek, Nevada for 6 weeks and shipping me off to my mother or my grandmother and, just doing her thing. Right. But I remember even as a kid, hearing her talk about how very valuable she found that program. And this is the first time she'd ever done anything like that. And so she ended up only doing it once, but I don't know, somehow it stuck. And so you fast forward, I had my head so down to the ground in the 90s in graduate school that I was sort of barely, I'll admit it, sort of barely paying attention to the Clinton crime bill. I mean, it was in the back of my mind, but I was like deep into graduate school at that point. and also kind of taking care of my mom. So it was way in the background, and I was in upstate New York, so I wasn't in an area where it really, you saw that impact, right?
Okay.
And so I was aware of it, but not as aware of it as I should have been. And then, of course, I was deep into the redistricting stuff, right? Which wasn't talking about how redistricting connects up with incarceration. That just was not coming up. So I, finish out graduate school, get to DePaul, start teaching at DePaul, and stumbled onto an article written by sociologists about felony disenfranchisement around 2007. And it was one of those, I could have had a V8 moments, like, why am I just now learning about this? I was embarrassed. And why is this written by a sociologist? We're talking about voting. Why is this not written about political science? And I started looking into who was writing about this in my discipline, and it was almost nobody. Or if folks in political science were writing in it, they were not getting published in political science. So I learned that my own discipline didn't have it really on the radar, and kind of relegated it to, at least from what I've been told by colleagues, to sociology, to criminology. And, but I remember being very frustrated by that and just trying to dive into more of this while still teaching 7 courses a year, on a quarter system, and just have a life.
Right.
And so but I started to incorporate that article and more like it into some of the courses that I was teaching, particularly the voting rights, because I teach a class on voting rights law. And around 2010, like many of the best things in my life that have happened to me, it's been by accident. I wasn't looking for it. It just came to me. DePaul, in his wisdom, 2 colleagues at DePaul, 3 at the time, instituted started teaching courses at Stateville as part of the Inside Out Prison Exchange Program. And the Inside Out Prison Exchange Program is nationally based, up until very recently at Temple University. Is a woman, Lori Pompa, who sort of innovated this program that trains instructors to teach classes in a prison with incarcerated and traditional campus-based students, hence Inside Out. And the whole point is to break down those barriers between insiders and outsiders. So
we bring unincarcerated students into the prison?
Yes. So the model is to bring traditional campus-based students, your typical 18 to 21-year-old cohort.
What year did this start? Where they started
Inside
doing
Out has been around. This program has been around for about 26 years now, and it started out of Temple University at Graterford Prison in Pennsylvania.
How was that at first, though? To combine the students.
This was a woman who had been teaching in the traditional model where the instructor just goes in. Now that's been around for decades, since at least the 30s, if not before.
Okay.
And one of my favorite parts about reading the autobiography of Malcolm X is talking those chapters about him taking these classes, his sister getting him transferred to a prison in Massachusetts where you had folks, it sounds like, from Harvard who were teaching there. So the individual instructor going into a prison to teach is an old model. Right. It's been around. This emerged from her teaching like that herself at a prison, and some of her students said, "Hey, have you ever thought about bringing some of your outside students in?" I think they were having conversations about her talking to her other students about this and vice versa. And somebody said, "Hey, just bring them in. Have you thought about that?" And, like so many other people, she's like, "Okay, yeah, I'll try it." And she did. And it caught, and it became so admired and so much in demand that next thing you know, she ends up creating this program to train other instructors how to do this. It's not to say that other people may have not have taken students into a prison setting alongside incarcerated students, but I don't think it was happening often. And it's also something that is difficult to just do. You really need to kind of get prepared for this.
What do you mean by that?
Well, it's a lot of things. The one thing that was really good about this training is, if you've never been in a prison, part of the training, 3 of those days, you're going into a local prison to be trained by students in there. And so you got to get used to even what it's like to walk into a prison or a jail. What kind of clearance do you have to go through? Are they going to search you? Are they going to pat you down?
What was the first year you actually did this?
At 20, my first teaching at Stateville was in 2016, but I went in with a colleague who was doing it already in 2015.
Mm-hmm.
And I went in on purpose several times with her in advance just to get me used to the process.
Do you remember what
in.
the first time was and what
Absolutely.
Could you kind of give us a sense of that?
So you walk in, now Stateville's old,
okay.
And so it's almost theatrical in its look. This big old red brick building, and ironically, some of the older prisons have really beautiful architecture. And a lot of them look like those big, pretty high schools like Lane Tech. You know, you could tell it's probably the same architects, high use type thing. So you walk into this building, this brick building that just kind of looks like a charming early 20th century brick building. But the first thing I noticed is how old everything was and kind of decrepit everything was.
Mm-hmm.
And then you get to the first set of big iron gates. I mean, straight out of the movies.
Mm-hmm.
Then you get to the second set. Then you get to the third set. You literally walk through 5 sets of these big iron gates. And again, it's an old place. So you have the staff with the gigantic key ring on their pockets.
Yeah.
Because they still open manually.
Sounds surreal.
With these gigantic keys. And they say gate, and everybody kind of stops and they open up, they let us through, and then they close it again. And then you go to the next person. And each time they're, depending on the day, they're looking through your stuff that somebody else had just looked through. So you're being scrutinized at a lot of these different gates. The other thing I noticed, first thing that really stood out is how many staff were just sort of milling around. There's a lot of staff. Stateville had a very diverse staff, and just how old the building was. And they had old photos of Stateville up around the top. You could kind of see, because some of the buildings have been taken down. And you could just see how everything had just been used. I mean, even the steps, the marble steps, it is a double set of marble steps that went up, and you could see the footprints, they were bowled down, kind of hollowed out just by all the footprints going up and down. Of staff, of volunteers, and of incarcerated people coming in and out. And then I also was struck by, we would come through the same entrance that family visitors would come through. And so just sort of seeing how they were being treated or where they would go versus where we would go. And for our classrooms, we were way in the back. So we just went through all these 5 gates, only 3 of which open and shut. 2 of them were sort of permanently open. And then it took me a minute to realize, oh, okay, that's a staff cafeteria. Oh, okay, that's where we went to go get fingerprinted earlier. But it's just big and old and loud, but with really shiny floors. There was always incarcerated workers there mopping the floors, really shiny floors. Some murals that were painted on the walls by incarcerated people there. So this juxtaposition of, new artwork on these old crumbly walls and these old cement floors that were so shiny. I used to worry about slipping and falling. Like, they really like shiny floors.
Yeah, apparently.
And then Stateville has the last remaining roundhouse in the country. There weren't very many of these things built, but they were circular cell houses that supposedly made it easier for staff to surveil. You needed fewer of them.
Oh, I see.
It apparently didn't work as planned. And if you look at old pictures of Stateville, they had 3 of those roundhouses. By the time we got there, they just had 1 left. Then you pass the dining hall area. So you kind of look over and you see people in there who are eating, or sometimes we would have to wait as they ran what they call lines of people going to eat. So we had to wait until maybe 60 or 70 people passed through, and they were all, because this is a maximum security prison, anybody who's in there, who's incarcerated in there, they don't have free reign. They have to be escorted, whether it's 1 person or 50. So you see all these lines of people being escorted either to what they call the chow hall or to the classes. And if we got behind them, then we had to wait until they went out in front of us. and then another 2 or 3 gates. It's just, I'd lost count of the amount
Wow.
of just these iron gates.
Because you get, I mean, it sounds to me that being there from an outside perspective and coming in there for the first time or the first few times, you not just understand the level of incarceration and scrutiny and surveillance, you feel it to a certain degree when you're in the space.
The thing that really struck me after about the 3rd visit is you're literally breathing it up. There's a lot of chip paint. You know, it was an old building, right?
Right.
To get there after a heavy rain, you could see sort of puddles in the pathway. You know, these are covered pathways, you know, or within the building, but still leaks coming down. So you would sort of be walking through puddles. In some places you saw mold. So you're literally kind of breathing it up. And then they walk us around the yard, and you pass some cell houses that have been there for years, but were never used. I think there was, they discovered some building code violations, so they weren't even in use, but there were several of those. And then you finally get us back into what they call the classroom building, which I think probably was originally a building for industrial training. It looked more like a auto shop kind of building.
Okay.
But it had these classrooms that were in it. And of course, everything is brick, cinder block. This is a slightly older building, probably built newer, built in the 50s maybe, but everything is brick and cinder block. And so everything's loud. The voices really ping off the walls. You kind of have to yell. And when it's hot, there's no air conditioning. And so they have these huge, 3-foot wide industrial fans that are going. So you got to yell over that. And, everything is just kind of old and beat up, but you walk into those classrooms and it's just like, wow, it was just a fantastic learning environment. People came in there ready to learn, ready to talk.
Well, what kind of topics
put that other stuff behind you?
Yeah. What kind of subjects would you teach, and what was the interaction like, particularly with did you start with the Inside Out with both people,
I started with Inside Out. So,
okay.
I was also Inside Out also trains when it was in-person training. After COVID, it kind of went all to virtual, but I was trained at Oregon State Penitentiary, a similarly old penitentiary or prison. And so 3 of those days we went into the prison setting and worked with the students, and they talked about, they ran us through about how these courses were structured and the differences in teaching somebody who's been in prison. And the biggest difference is really you're just working with older students, is what we would call non-traditionally aged students, 25 and up.
Right,
and you do interact with them differently than you do with the standard college age students who's living in a dorm.
Right.
And that's an important difference to know. And so I feel like I was advantaged in that case by having a mom who taught adult learners, right?
Right.
Because I would visit her often in class and I could see that difference. And the Inside Out model is structured around discussion-oriented courses, i.e. not somebody going in lecturing for 3 hours. They're taught in a circle. And so you have inside student, then outside, then inside and outside. So you have to learn how to, if you are going to lecture turning around. Lots of times you may have a classroom that doesn't have a good chalkboard. Mine didn't have a good chalkboard. So it's not like I totally use whiteboards and chalkboards. It was weird not being able to do that in my classroom, because the chalkboard was just so bad. You could write on it, but it didn't show. Also, the assignments, they teach you how to tweak your syllabus in a way that works better for a discursive type format. And the assignments are always group-based, which is difficult. Because it's not like the inside and outside students can interact with each other once they leave the classroom, but they make it work. And so, we learned from the guys about, here's a way to sort of tweak your project in a way that would work under these challenges. So the Inside Out training is very helpful. It's not perfect. Nothing is perfect, but it really is helpful to teach instructors how to work within all the limitations, particularly communication limitations and technical limitations. You may be in a prison like Stateville, where until after COVID, we had no computers in there and we weren't pulling up stuff on the screen. Readings all had to be brought in. You couldn't say, oh, go to your course assistant and just pull up this reading, because they didn't have computers. Now more of them have tablets. So I used to joke that for an older instructor, this is great, because we're used to that.
Mm-hmm.
For newer instructors where everything is online, it takes adjustment.
Mm-hmm.
Now there is more capacity in some places for students, incarcerated students, to have some internet access, or at least access to curated resources, databases. In some case, like in the Illinois Department of Corrections, we are able to use Zoom to bring in speakers, or maybe if I can't come in, I can Zoom in, although that's not ideal. But there are other prison systems that still don't allow that, right? So it's a real patchwork. And so it's, I remember hearing the phrase meatball surgery when I used to watch MASH. It's like meatball teaching. You have to be really resilient. You may have access to Zoom and then come in that day and the staff says, yeah, Zoom's not working. You're on your own. And you're like, okay.
Right.
So you have to be really, really resilient. One day you may get all your students. Another time you may not. Because at a maximum security prison, typically they can't take themselves to class. They have to be brought to class.
Right.
All roads point to the movement staff. If they're not down with these programs, sometimes they can make it difficult. They can say somebody refused, or they just get them in there late, or they come in and get them out early. So there's a lot of dances that you have to do.
Yes.
With staffers there, some staffers I got along with great. The last year I was there, it was all I could do to not explode at the administrator, who could make things difficult for a lot of people. I'll just leave it at that.
Yeah.
And so the training also helps you work within situations that you just can't control. Academics are used to being, it's my classroom. We're like judges, right?
Yeah.
Not there.
Right.
And so it's also a real exercise in holding your tongue. It's tough. So, I was invited to DePaul. Backing up a little bit, DePaul initiated its Inside Out program at Stateville in 2012 with one course on restorative justice. And the Inside Out program is structured around the restorative justice model. And so there's also encouragement. You can teach in any topic, but there's encouragement to try to infuse some aspect of restorative justice into your course. You don't have to, but it's encouraged. And it was the same course that was being taught for about 2 years. And needless to say, there was a whole lot of interest on behalf of both inside and outside students to teach other courses. And so I had been teaching a course on law and politics. It's a very standard course in my department. I had just started teaching it. One of the people who started the Inside Out program knew me. And she said, "Hey, Chris, do you want to teach this?" And I was like, "Oh, I never heard of this program, but it sounds really cool." Sure, because I don't think about things, right? I just say yes. And so I got trained in 2014, but didn't start teaching at Stateville because of scheduling reasons until 2016. But it gave me that year to go in periodically with my other colleague to get that lay of the land, which was so important.
I bet.
Because it was really all about that and learning who to suck up to and how to do it. And so that by the time I started teaching there, I knew the process. They knew me. I wasn't this new person. And it made things a whole lot easier to have that experience. And it gave me a chance to meet some of the students who I ended up, the other person's students who I ended up having in my class. So I taught there every other year, starting in 2016, with the exception of the COVID break. My 2020 class, unfortunately, got canceled. My 2022 class, I ended up teaching via Zoom. They didn't let me bring the outside students in, so I was looking at 2 screens, one with the DePaul, and then I would go into Stateville and alternate. That wasn't ideal, but it was better than nothing.
When was Stateville closed down?
It was closed down the COVID closures were 2020, and then I was able to teach back in spring of 2022.
Oh, okay.
But it was like a partial opening. So they let the instructors come in and some volunteers, but they were still a little nervous about having full cadres of other, students coming in. I don't know if they were worried about liability, but it was a partial open. And then after that summer, I think it opened up more fully. DePaul started at Stateville in 2012. I started in 2016. By 2018, we were not the only people there. The Prison Blessed Neighborhood Arts Project also started teaching there in 2011 or so, and that's a self-described name. They began a BA program called the University Without Walls through Northeastern Illinois University. And so by 2018, they graduated their first BA cohort. Wow. And around 2018, also Northwestern University started their NPEP, Northwestern Prison Education Program, also offering a BA. And around that same year, North Park University started a master's program in restorative theology. It was within 5 or 6 years, you went from no college programming to 4 different entities with 3 degree programs. DePaul ended up being the only one that didn't have the degree program, but we were one of the first people in there, and we were the only ones at that point bringing in cohorts of outside students. So the folks there had a lot of options to choose from, and in some cases, we're sort of in 2 programs at once. The DePaul courses and the PNAP courses often created sort of the groundwork for students to then go into the BA and then the MA degree program. So it was really incredible. It took no time for those seeds to plant, to drop, to germinate, and to really mature. And, and then took a while to pick the momentum back up after COVID, but they did until the closure. And so now everything has just been kind of relocated.
Well, it's, I would imagine that I was talking to Michael Dees about this the other day, and I said, I bet he was going on and on about the intellectual curiosity
Absolutely.
And the level of critical thinking of some of these incarcerated individuals, which really blew him away on many levels.
Absolutely.
And oftentimes some of these students from the outside would be intimidated by them because they were so focused and astute on so many things. And, I was thinking of this forced focus. So for lack of a better phrase, when you're in prison, you don't have a lot else going on. So this is what you focus on. That's your outlet. And so he was really struck by that over and over and over again. And also, and I just wanted to bring up what we touched on earlier, was this this legislation that was signed into law, I believe in 2019. It's called the Reentering Citizen Civic Education Act, that I believe you said your students wrote. You didn't have much to do with it. You typed it up. Could you speak a little bit about this? This is so fascinating to me, and my limited understanding is that this legislation requires people coming out of prison to be educated about civics in a substantive way to exit the prison system. And that's such a refreshing thing to hear, that type of a program actually exists, and that it was written and conceived by people who are incarcerated. Can you speak to that a little bit?
Absolutely. So 2 things I want to say before that is the perception that people in prison are uneducated and uninterested is really wrong in a lot of cases. They may not have finished out their college or even their high school, I should say, but there's a lot of intellectual thirst and knowledge and accomplishment that is happening amongst a lot of incarcerated people, many of whom are self-taught if they don't have programs. And so the first thing I learned is you can't be surprised at what you see in there. And now Stateville was also, because it was maximum security prison, you had people there in their 50s, 40s, 50s. And so, sometimes you take to this later on. But I learned not to be surprised, because to your earlier point, when you meet people where they are and they're ready to do this, they're ready to do this, right? And they have every bit as much capacity as any student that I've worked with, either at DePaul or in my undergrad at UC Irvine or grad school at Cornell, right? So and sometimes instructors have expressed surprise, and you get that moment, right? Because it's you shouldn't be that surprised. But it really taps into stereotypes about people who are incarcerated, whether it's based on class or racial issues or whatever. The other phrase that I've kind of come up with is, folks there are exceptional, but they're not exceptions, if that makes sense, right? Because there's so many who have this capacity to accomplish
it's amazing. It's amazing because I would, obviously, when you're incarcerated, there are so many messages, both directly and indirectly, that you're not worthy, and you are less than, and a whole host of other things that are being thrown your way, so that your level of self-esteem is very, very low, I would imagine. Right. Just in general, there's a huge need to just stimulate your mind, and there's not a whole lot of outlets to do that in prison. And then all of a sudden this system comes in and says, hey, we're going to stimulate your mind, and here's going to be an outlet, and we're going to speak to you to the possibility that is present in you, that you've perhaps even forgotten about yourself. And now all of a sudden somebody's tapping into that, and that process must be so, I guess the words are inspiring.
Well, and again, in a lot of cases, in some cases, folks, minds are being stimulated. In a lot of cases, they already were. And so what they're able to do when colleges come in is actually latch on to that, but they were already doing a lot of self-education in the process.
And interact with other human beings that are kind of fostering it to a degree.
And sometimes that was already happening. And so one of the things that I learned a lot is how much folks have really these deep conversations on the yard, in the chow hall, in the living unit, if they have a pod type living unit. Some people are watching a game, but it's like anybody else. You also have this you got the nerds, and they're having these conversations, and so they're already lit up, right? They just, in many cases, they don't have the programs to attach to if it's not there.
Okay, gotcha.
And so some do, there are some places some universities that will do correspondence, and so folks will find those types of courses. So one of the first things I learned is the nerd folks, they're there. And what really lights that fire is when they have a program to then latch on to, and then they're really good at nerding out and then getting other people and tapping into other people like you're describing, who may not even know that they can do this, and then realize, oh, I can. So, one of the things that I really got so much out of was hearing how some of these folks would recruit amongst themselves to take these classes. And some of the folks that I worked with when I was being trained at Oregon State, you did have some that would say, yeah, my cellie told me to take this class, and I looked at him like, man, I can't do this. I don't even have my GED. What are you talking about? And the friend would say, no, you got to do this. And they would, the person would tell the story about how he was petrified, through this whole course. I'm going to fail. I don't even have my GED or whatever. And then they get that A. And let me reinforce here, we do not simplify what we're teaching. We do not grade differently, the folks on the inside or folks on the outside, same scrutiny. So then you get this person that gets the A, and then they're like, and then they can't stop, because this might be the first positive experience they had in a learning environment, particularly if they went to schools, K-12 schools that didn't offer them that, or, they were just too busy living life, trying to make money in ways that ended up getting them where they are. Or, of course, you have people who are wrongfully convicted. So one of the first things I learned is there were a lot of folks that already had that fire. Again, the nerds were there.
Interesting.
And once they got programs to attach to, then it brought out a bunch of people who didn't even know they were nerds. And so sometimes I would, listen to them talk like, God, do you guys do anything fun? I'm like, have a life, So yeah, there's a lot of nerddom that is incarcerated, where some people know it and then some people don't know it, and then discover later on, I really am a nerd. I'm really digging this. And so one of the other first things I learned about this type of programming, whether you're bringing in outside students or not, is how mutual the education is. particularly depending on the topic. Some of these folks are so incredibly well read that I'm making notes like, oh, okay, I got to go read that.
Oh, so the teachers are learning just as much as the students are.
Absolutely mutual. It is not one directional. And you brought up the other point that Michael Dees was making about how some of the outside students, realize, ooh, I got to step my game up. So I have a great story of the first time I taught there. Each time after a session was over, the outside students, we'd leave. We kind of gather in a circle out in front of the visitor center and just do a really quick debriefing before we got in the cars and left. And so that one session, everybody was really quiet. And so I'm worried. I'm like, uh-oh, was there a rule violation? Because there's so many rules, right? So the first thing I thought was, okay, was there a rule violation? And it's hard to get that out of people, right? And so they were all just kind of hanging their heads. And I was like, what is going on here? And so one of the students, and excuse my French, shook his head and he's like, we just look like shit today. And I was like, well, yeah, since you bring it up, you did. Because they were very slow, on the Q&A stuff. And the inside students were like, again, nerding out, right? And the outside students are just kind of like, because they hadn't done the reading. Just like they do on a regular basis, right? They went in there thinking, I don't have to do the reading. Well, they got showed out by their classmates.
Wow.
And so I just laughed. I was like, well, I'm glad you figured that out. I'm glad that's all it is. And by the next week, they came and they had done that reading because they didn't want to look like shit again. And so based on that experience, because we interview our outside students, I tell that story. I was like, okay, you better be on point because, regular students, we would skim on a good day. No, you need to read this stuff 2 or 3 times over because I guarantee you your inside colleagues and classmates have read this stuff 3 times over and you better be ready. Right. Now, what's also happening though on the inside, I've learned is some of them are like, I have to read this 5 times over because I have these DePaul students coming in here and I can't look like shit. So there's that perception as well, right?
Interesting.
But for an instructor, it's great. Right?
Yeah, for sure.
Because it's like, I don't have to pressure them to do the reading. Yeah. They're pressuring each other to do the reading.
Yeah,
so in some ways it's the best kind of teaching because you have this mutual kind of like, oh, I got to get my stuff together. And let's be clear, it's really difficult to do the kind of reading and work in a living space that is so small, in some cases very dark, extremely loud, with a whole lot of distractions. And this is whether these are 2-person cells or pods where you may have 40 people to a pod and you have 15 conversations going on and then somebody's watching TV and then you got the checkers and the chess game, all these distractions, right? And you're sitting here in your little book. Or I remember when they took us on a brief tour of the cell blocks, and the cell blocks at Stateville were 5 levels high and just the open bar gates. And so you're just hearing tons of conversation. And, if you're on level 2 and your buddy's on level 5, they will be yelling up and down conversation because they're locked in. It was an open movement. So they're yelling up and down. They could be talking about the game, conversation they just have with their kids.
And it's pinging off because there's
off the walls.
Because it's just concrete and steel. There's no sound absorption pads.
No.
So it makes it exponentially more difficult to concentrate and read.
TVs,
fans, my God, I couldn't imagine that.
Staff, the crackle of the walkie-talkie, it's just so loud. And I remember asking the staffer on this tour, I said, is it always this loud? Is there a curfew? And he's like, no, it's just this loud. And so now you're having to study in all this.
How do they do it?
And so even if you have a lot of time, I'm not saying every prison setup is like this, but this is how it was at Stateville. Even if you have a lot of time, it's very distracting. You may have a cellmate that insists on watching something on his TV really loud, even if he knows that you're trying to study. And too bad because it was a lockdown You were locked into those cells unless you were in a class, on a visit, unless you had something to do.
Wow.
You were locked in there. And so whatever noise was around you was around you. And the cells, even though they had a big light on the back of the wall, I don't think they had smaller lamps. And so when those lights were off, it was really, really dark. So it was a very difficult place to do work, and they had no desks. So, they had foot lockers. They could either use that as a desk or just right on their laps. So they had nothing.
Oh my God. When these students that come in from the outside complain one iota, you probably just look at them and say, what are you complaining about? Please don't complain to me. Go spend time in a prison. I bet that comes up. Please don't complain.
We have discussions about that with the outside students before we go in.
I bet.
Now, it's not to say that, outside students don't have some of these issues. If you live in a dorm,
sure, of course.
You got roommate issues the same way you have cellie issues.
Sure.
You may be in a suite where everybody's just being jerks, but at least you can get out and go to the library or something like that.
Yeah.
So there is some, or you may be studying from home and your siblings are just annoying you, or your parents are like, get up and wash the dishes. So, we do have distractions, or we work.
Mm-hmm.
It's just a different kind of distraction, but a lot of people, say, "Oh, well, they don't have anything else to do." That may in part be true, but there's a lot of distraction, and then a lot of incarcerated people do have jobs, if you want to call them jobs, given how little they're paid. But they do have jobs, and so sometimes they are out of the cell, or they have distractions from studying there. And the same thing with an outside job. If you got work to do, they're not going to let you sit there and work on your paper, for the most part.
Right.
So there are some of those distractions. So it's but the distractions are just, multiply louder and more chaotic in a prison, especially an old prison structured the way that one was.
Oh, I'm sure.
Compared to others, since then I've visited other minimum security prisons and mediums where it seems to be a little quieter. But at the end of the day, it's a prison. Your life's not your own. You can be interrupted at any time. You just have to deal with that.
That's incredible. It's incredible.
And so and there's so many designs to prison housing that can make a huge difference as well.
What do you mean?
Like the pod housing, you may have a room where there's 2 sets of 10 bunk beds, 2 rows of 10 bunk beds, and just open space. And so there's just no closed private space. There's no quiet. Oh my God. And it's just everybody's kind of in that same space. That's very different from your classic, 2 people in a cell. I see. They're both problematic, but in very different ways. Right. In the open, so in the 2-person cell, typically somebody, has a TV because you can buy those, or your family can buy those. And they're not huge, but if somebody has it on, it's on. I don't think they have earpieces, so you're hearing whatever's on. In a pod, there tends to be 1 TV up on the wall, and I can imagine, I don't know how they decide what's going to be on there. But there's usually a crowd, up there and talking, especially if it's something like a game or, anything else you want to yell at the TV about. And then often in more collective living settings, you have the card game, the dominoes game, the chess game. Those can get really animated, as games do. And so there's just a lot of, it's a different kind of distraction and noise. Now, in some of those settings, you can go back into your cell to kind of quiet yourself down, but I'm learning about how many just different physical structures there are for how people are housed, if you will, in a prison or jail setting.
Sure. I'd love to. I'll just come back to this 2019 act that was written. So if you could just speak, because we've covered a lot of ground. This has been incredible. I just want to make sure that we get this in.
Yes.
How this came about, and what it was.
That's easy. Actually, I can tell you that pretty quickly.
Okay.
So when I taught the course the first time in 2016, and each time I teach it, I close out the last 3 weeks of the readings are on felony disenfranchisement, prison-based gerrymandering, and then at one point I added lack of access to voting for people who are in jail. And in jail, if you're in jail pre-trial and you're otherwise qualified to vote based on your age and your citizenship and you're from the region where the elections are happening, you are eligible to vote. That's good news. The bad news is it never happens because most elections boards don't set up polling stations in the jail, and it takes a lot of planning to ask for an absentee ballot while you're in jail. But you do
just probably
have
one hurdle after another.
Yeah, it takes planning, and you're thinking about your case. But people who are in jail pre-trial, if they're 18 or above, citizens, residents of that region, and are not currently serving another felony, you're eligible to vote. That's across the country. And then the felony disenfranchisement statutes differ across the country in many ways, but the big similarity is, with the exception of Vermont and Maine and the territory of Puerto Rico, and I think now if you're in a federal prison, although I have to check on that one, you are not allowed to vote while you're currently serving a sentence in prison. And then voter eligibility, the restoration of it really differs from state to state. It's like a patchwork quilt. And so I cover those topics. I closed out the class on those topics. In the first year, didn't talk about jail, but we closed out on felony disenfranchisement laws and prison-based gerrymandering. Prison-based gerrymandering is a practice of counting incarcerated people in an electoral district, even though they can't vote. And so it's almost like a 3/5 compromise because they're being counted for purposes of funding, and it's a lesser extent with respect to funding. They're kind of counted as constituents, even though they're not, because they can't vote. Illinois just passed a law recently that doesn't do it anymore, but it's up to states whether they want to do this. And so for the class projects, for that first course, there were 4 teams. And so there were 2 teams that did their projects that were related to felony disenfranchisement. And then the other 2, I think, had to do with prosecutorial misconduct and I think sentencing. And so after the class ended, I established what's called a think tank. So when we get trained through the Inside Out program, we are encouraged, if we have the time, to create a think tank that would allow our students to keep meeting about the class even after the class is over, entirely voluntary, because it's the only way they could continue to work on their projects. And even if the outside students aren't able to come in because, they graduate, they leave, or if it's a more medium security setting, people who are on the inside are paroled, et cetera, it allows these projects and conversations to continue. Totally voluntary. So I said, okay, I'm going to start a think tank because some of these projects are really good. Let's see if we can clean them up a little bit, because how much of a group project can you do when you have so many restrictions on talking with your group mate? And on a 10-week quarter. I mean, it's hard to get a good group project just on a 10-week quarter under even ideal circumstances. And so I said, okay, let's start a think tank. You all choose which projects you want to sort of polish up, and let's have fun with this. Because the project, let me back up, is structured around create a legislative proposal. Just think big. So I said, okay, you all choose which ones you want to clean up, what topic you want to focus. Do you want to come up with a new topic? And so it took a few months to kind of figure it out. But one of the clear decisions was they wanted to continue on this issue of coming up with some kind of legislative proposal around felony disenfranchisement. And so one of the questions they had was, how many people even know about this? How many people know that in Illinois, your voting eligibility is restored once you leave the Department of Corrections? There's a lot of there's not much knowledge around that. And so like so many things happen. Some of the guys were talking about it, and one of the guys said, yeah, man, I was talking about this to folks on the yard and then in the child line. And so then somebody said, it might have been me, I can't remember. It's like, you should do a survey. And so next thing you know, they're doing it. We're sitting there writing a survey. I don't know anything about surveys. And it was very unofficial, but they ended up doing a survey, and they got about 200 responses back. And the first question was, did you know that your voter eligibility is restored, that you have the right to vote when you get out of Department of Corrections, Illinois Department of Corrections? Only about 30% of the respondents knew that. One question was, have you ever voted before, prior to your incarceration? 2/3 said they had. This really blows up standard thinking, by the way, in the academy about voter apathy amongst incarcerated people. 2/3 of folks said they had voted prior to their incarceration. And we said in any kind of election. I mean, we made it broad. This could be high school principal, student body president, but did you vote? Another question we asked was, do you know how to regain your voting rights once you get out? About 25% said they did. So another question was, and they came up with their own questions. If you could vote when you get out, will you? And if you could vote while you're inside, would you? And those responses were about 98% yes. So again, it totally blew this notion of political apathy out of the water. Now, granted, this was a maximum security institution, and where a lot of the people were older. So it might have been biased that way. There's no way you're going to get a random, perfectly scientifically random survey in a prison. You can't.
Right.
The response rates might have been different if the average age there was 25 as opposed to 45, because as we all know, older folks vote more regularly than younger folks. And I say that with no judgment whatsoever. It takes a while to build that habit, right? And to see the relevance. But still, those responses blew standard thinking out of the water. And then one of the questions was, if the Department of Corrections offered workshops on voter education, would you participate? My cynical self, I'm thinking, it's only going to be about 25%. Who wants to do that? I can barely get these people into my classes. And 85% of the respondents said yes. And so from that survey, they decided to completely change the project that they were working on. I shouldn't say completely, but change it to, let's propose a civics education workshop. And so over time, they boiled it down to say, let's structure this for folks who are leaving around the exit process that already existed. And when the question came up, who would do the instruction? They said, well, we can do it. The Illinois Department of Corrections has a very vibrant peer education program for outside entities that also give these types of workshops, like the Department of Health. They have to go through workshops with the Department of Health. I think there's one around employment or housing. And so Department of Health people come in and train the peer educators on what they need to tell folks as they're getting out. And then the Department of Health will periodically evaluate them. So they said, just do it around this model. And that way the peer educators are already there. Incarcerated people, they argued, more likely to kind of hear this from a peer educator than from prison staff or even somebody from the outside. And there's deep interest in becoming a peer educator. So it would generate more interest in people doing that. And then the peer educators then train each other. As somebody gets their out date or their parole date, if I'm getting out, I would then train you if you have another few years. And then, so it's like that, the bread dough that people pass down kind of concept to each other. And so that's how they wrote it. And they structured it, to be in sort of 3 sessions within the last year. I mean, it really got granular. And over time, we brought in people with Chicago Votes, which is a very vibrant organization that targets and really mobilizes voters under 30. So I feel honored to be working with them. And also voters from communities of color that have low voting turnout. They had been pioneering voter registration processes at the jail at the same time, started right about the same time.
Mm-hmm.
And one of the students in my class had graduated or was interning with Chicago Vote. She hadn't graduated yet. And I had just met them through another circumstance. So I said, okay, let's get Chicago Votes in here because they organize. They know how to kind of get boots on the ground, and they can share some of the perspectives that they're getting in the jail, what they're hearing in the jail when they register people to vote.
Mm-hmm.
And again, this one student who had taken the class, she had both perspectives. This same student, and I'll say her name, Alex Boutros, all roads point to Alex Boutros when it comes to this. She then started to intern with State Senator Sonia Harper, because one of our questions was, if we have this proposal, who do we give it to?
Mm-hmm.
And so she had then been interning with State Rep Sonia Harper, whose district includes parts of North Inglewood.
Okay.
With high concentrations of returning people. She was very interested in this. And then the third road that was brought in is, again, through Alex and myself, we brought in Ami Gandhi, who is the lead voting rights attorney with the Chicago Lawyers Committee for Civil Rights. Mm-hmm. I had met her in a totally separate setting, but I was start telling her about this, and I said, would you be interested in coming in a couple of times to meet with folks about how this could be converted into legislation, because that's something that they had done. And it's so funny. She's like, oh yeah, I can do that a couple of times. She then became one of the most regular members. So this think tank expanded to include consistent collaboration with Chicago Votes and the Chicago Lawyers Committee for Civil Rights. Mm. And so we there had guidance in how to structure a bill, because that was way over my head. I never took a course, believe it or not, never took a course in state politics. I've read all sorts of laws. I've never been trained how to write a law, right? Mm. But they kind of knew how to do that. Chicago Votes was very good at lobbying in Springfield about these types of issues. And so they brought in that knowledge, and we wrote this bill. They wrote this bill. And what was really stood out the most is by this time it's 2018, so I taught a second class, brought them into the think tank. They too had about 2 groups that were focused on this. Mm-hmm. And I was trying not to shove this down their throats, right? They chose the topics that they wanted to do. Of course, it was near and dear to my heart. Mm-hmm. But some of them joined in on this project. Some of them still did their other, there was a big issue in parole reform. During that time, totally separate, there was in 2018, as the momentum was really building on this bill, there was a debate team that had been organized at Stateville, and it was just Statevillers debating each other. It wasn't like the model where they bring in folks from Northwestern or DePaul. Mm-hmm. And their debate was around parole, because Illinois has a very weak parole system. It basically doesn't have one. And so they debated 2 different approaches to restoring parole. When that happened, somebody at Stateville, I think, had invited several dozen legislators, and they had this debate in front of legislators live at Stateville, handed them their handwritten bill, I think it was handwritten, mm-hmm. around parole, and then got a chance to talk with legislators after the debate. And I still regret that I was out of town when that happened. So by all accounts, it was this very successful debate. It was so successful, the debate team was disbanded a week later. Yeah, the whole, you can look it up. Because it was considered too much power. I'm not...
Dangerous.
Yes. So several students in my 2018 class were on that debate team. And at one point we were forbidden from talking about it the guys were forbidden from talking about it under threat of being thrown in segregation. I mean, it was nuts.
Wow.
So here we were writing, and this is all documented. Here we were writing another subversive, dangerous bill, right, around democracy and civic engagement. And we almost had to whisper to talk about it in class because we didn't want to be overheard. And so I one of my big regrets was not being able to say, as I testified for this on the outside, where it was written. I wanted to be able to say, we're writing this in Stateville. I didn't want to say it because I didn't want to get us shut down. And we agreed on the inside, let's just not emphasize that because we don't want to get the thing shut down. But the Chicago Lawyers Committee and Chicago Votes, they had access to the legislative, I think it's called Review Board, LRB. Mm-hmm. They are the entity at the state level that will take a citizen written bill or any bill and convert it into the proper format with all the numbers and the coding. Because again, I don't know how to do that. And then Chicago Lawyers Committee vetted it for its legality. And we presented this bill to Representative Harper. And then we brought on Senator Robert Peters as a Senate sponsor. He was new at that time and just, very full of energy, as he still is. And they ran with that thing. They really ran with that thing. And it was in some ways a simple ask because it was not asking for new rights, right? And the guys were very strategic about this. They were very strategic about that name. Let's put civic education in there. It's hard to say no to civic education. Mm-hmm. And it was, in fact, hard to say no to civic education. And it passed almost unanimously at every step. And it was also written in a way that didn't cost the DOC money. Again, I wouldn't have known how to do that. The guys on the inside, they knew how to do that. And so I ended up having a conversation with the same person who had shut the debate team down. And she asked we were in Springfield when we had this conversation. Okay. And her main concern about the voting education bill was, was it going to cost? And I said, no, we have written it in a way, or was it going to cost? And was it going to create kind of a new timeline? I said, no, it's been written in a way that comports with your existing exit processes, using peer educators. And so that, will prevent the costs, et cetera, et cetera. She's like, okay, great. Go with God. I mean, she thought it was great.
But this person was the same person that shut the debate team down in prison. Yes. For what I'm just flabbergasted what their rationale would be. Because they were, we know why they shut it down, but what would their on paper surface explanation be? The best article I've seen on this is written by Charlotte West. And when we get off this call, I'll dig it up for you. By the way, the coach of the debate team, Katrina Baugh, is still suing about this on First Amendment grounds. She went to Allen Mills at the Uptown Legal Center, and they're suing over this on legal grounds, First Amendment grounds. Yeah. Good. So that lawsuit is still in process. But the Department of Corrections actually recently settled with the people on the debate team who were censured for this. They settled recently for that. So Charlotte West just wrote a really, really good. She can encapsulate it way better than I can, because at this point now, I'm getting a little bit rusty. Mm-hmm. And so this legislation went through the state legislature pretty quickly and unanimously,
fairly quickly,
and it became law pretty fast.
It very quickly became law. It was proposed initially in 2018. Okay. Yeah, and it was signed in August of 2019. Incredible. It was signed with a companion bill that doesn't have a name, PA 10440, I think, and that mandates voter access for people in jails, and it also includes some civic education there. That bill had a hiccup because Governor Rauner at the time seemed to read it as creating too much work for jail staff. It's not clear how closely he read that, but they got over that hiccup. And so once that was clarified, that was signed on the same day. And so there's, I can send you press releases.
Yeah, sure.
It's been written about that, but
that'd be terrific.
It was written at Stateville. It was the idea of my students, both incarcerated and traditional students. And, I added insights, but I didn't write it. They wrote it. It was their idea.
It's almost the epitome of everything we've been talking about thus far with your experience educating people in the prison system, and also them really taking action and creating something tangible that makes a humongous difference. Right. And also the way they went about including peer-to-peer education is just brilliant. I mean, everything you're saying about this is incredible. And anything, as we wrap up here, I just want to let you know, any links you send me, I can put in the show notes on this episode. This has been unbelievably enlightening.
Thank you.
Thank you for not just being here today, but all the work that you have done and continue to do. It's unbelievably refreshing to hear about this type of work that's being done, that's bringing about something positive as opposed to all the news that we've been hearing. Yeah, you're absolutely welcome. And this has been really illuminating on so many levels. Are there any parting shots you'd like to? I know this is an ongoing conversation for sure, but are there any parting shots you'd like to give us right now?
I think the main thing I want to just say, I'll try to be brief, is the good news was the law was signed. The bad news is it went into effect in January 2020. So that means implementation was stalled.
Wow.
For quite a bit of time because life was stalled, right?
Oh, right. Of course. Of course.
But I do want to say that the Department of Corrections has been very, very supportive in implementing this law. They have not thrown up any objections. And so even though everything really got stalled for about 2 years, around 2022, again, Alex Boutros with Chicago Votes, and the Chicago Votes took the lead of training the peer educators, doing the initial training at this point via Zoom, because now they had become open to Zoom, right? And so that meant they could train groups from 4 or 5 different prisons at the same time on the one Zoom screen. We wrote up a real quick and dirty curriculum to go with this. And so training resumed in 2022 and has really gotten very well organized. Hundreds of peer educators have been trained at this point. Of course, many of them have cycled out. But it's really become very consistent. DePaul is now getting more involved in that. But there are peer educators who are being trained. And in recent months, one of the main trainers on the outside was one of the first people to get trained as a peer educator on the inside. And so Brian Beals, who had been wrongfully convicted and incarcerated for almost 40 years.
How many? 40?
Almost 40.
Wow.
Really, really invested in this. And now that he's on the outside, he has kind of becoming one of the main trainers of peer educators because he was one. And so we're really, really excited to get more momentum behind the training. There's still gaps. It's not really clear that every single person leaving is getting all the training in person. That's really hard to implement as a whole, but I think at some point we'll get there. But the Department of Corrections administration has been very supportive of this since day one. And I'm just so excited that now we're going to be working with more peer educators who are now out, who are now going to be training via Zoom folks who are in our the adult transitional centers, kind of the halfway houses, and who are really gearing up to continue this work, not just in prison settings, but just in their communities as people who have delivered these workshops. And so anytime I wasn't as able to participate in as much of the training as I would have liked, there were a lot of them that conflicted with my class schedule. I'm now making sure I don't teach during class during that time.
Right.
And each time I sit in on these trainings in recent months, it is astounding the energy that these peer educators bring to the room, the passion that they bring to the room.
I bet.
Brian Beals also started a theater project called the Mud Theater Project. So he's really tapping into that. You know, how do you work the crowd, right? So he's really getting more involved in delivery. And, he's wanting to do talkbacks where they're going to give critiques like, you know what, Steve, you could have said this one like this, or you could have led with that, right? So he's really tapping into the theater and the performance aspects, because teaching is performance, right? And especially if you got a dead audience. Some audiences are dead, some are live. So how do you? And so
yes,
that
for sure,
is so exciting. They came up with an instructor's manual. He's going to be co-revising that, and it's just been so exciting in the past year or so to really see how the peer educators are running with this, and how they're having to pivot and engage differently at different institutions, because every institution has their flavor.
Right.
And again, some of them will say, yeah, well, the last session went really well, but the one prior to that was terrible. And then I'm in the room to tell them, well, yeah, that happens. And to just see their passion and their engagement, to present this information, not just to each other, but to really encourage and to continue to talk with people about this when they get out. I just can't say enough about it. And there have been staff now where if an issue comes up, let's say, because we have an example of the old literacy tests, and there's some staffers who have gotten so supportive, they'll say, well, hold on, let me look that up. I'll print that out. So they will look stuff up sometimes, the staffer who has access to the computer, if there's a question. And I'm so floored by the staffers who will do that. It's not all of them, but there are some. So we're getting more slowly, more staff buy into this. And it's very, very encouraging.
Oh, I'm sure. Wow. How inspiring. Well, Dr. Christina Rivers, thank you so much for being on the show. It's a real privilege and pleasure to have you. And thank you very, very much for being here.
Thank you. And hopefully you'll have some of these other folks on too. I'll send you their information.
Oh, absolutely. Absolutely.
Okay. Thank you.
Take care. All right. Bye-bye. Thank you for tuning into the show. If you enjoy this podcast, make sure to subscribe to hear more compelling episodes on Rhythm of Life, and keep an eye out for our upcoming series of how we as a society often incentivize all the wrong behavior here in the United States. We see this in the healthcare industry, the media, and in our educational systems, to name a few of the fields we will be covering. We will also be launching another podcast very soon called Ambiology, that takes a look at the left-right political spectrum from a historical perspective. It will be a deep dive into this paradigm that is conventionally thought of as static, but has shifted significantly over time. Ambiology will also examine the significant role public relations, also known as propaganda, has played in shaping perspectives on critical issues in the country. If you have a moment, please leave a rating and review so more people can hear about us, and share about Rhythm of Life on social media, and like us on Facebook. Thanks for listening. I'm Steve Ordauer.
This has been a Rhythm and Light production.